Welcome to our module covering the topic of religious discrimination. Let's begin. We have these topics that we're going to talk about. We're going to do a little introduction, then we're going to discuss the issue of what is religion. You may have noticed in several of our other topics, we spend a little bit of time in most topics trying to figure out what certain terms mean, because even though we might have kind of a general cultural understanding about what we're talking about, when we're looking at the law, we need to kind of dive into the details and have as much precision as we can with our language. And we'll see that the term religion is actually a pretty complex idea, and we want to figure out what the law or what definition the law has applied to those circumstances. It may be fairly different, frankly, than what you and I mean when we use that term in everyday conversation. We'll talk a little bit more about the prima facie case. It tracks very closely to what we've talked about in previous lessons. And then we'll talk about, kind of related actually to the prima facie case, the issue of the duty to reasonably accommodate. This is our first statute that we have not just the responsibility to not discriminate, but to do something more than that, to actually give a certain advantage to people to be treated in a more advantageous way because of their particular religious situation. And then very much related to the idea of reasonable accommodation is what is too much to expect? Where's the line? The religious person has the duty to, or excuse me, the right to be expected to be reasonably accommodated, but when it crosses that line and becomes an undue hardship, that's when the duty ends. And so we have to figure out how much is expected and when going any farther would be too much to expect. Then we'll discuss the topic of when people's religious sensibilities run up against each other. So you might have one employee who wants to proselytize or convert another employee. Well, they both have rights in that situation, and so we'll try to figure out how to maneuver in that type of situation where you have a lot of kind of conflicting rights and obligations with respect to employees. And then we'll talk about very briefly the idea of a union. If you are an HR manager or legal professional supporting an employer that happens to have a union in place, how is that going to affect it? If you happen to work for or support the union, what obligations does the union have with respect to religion? Finally, we'll talk about the circumstance in which a religious organization, it could be a church or a mosque or a temple or some other entity, or it could be something like a religious school. What obligations do those institutions have to not discriminate? And we'll talk about that really through two lenses. They many times obviously have the ability to discriminate based upon religion. I mean, it wouldn't make very much sense for a Jewish synagogue to have to equally consider Christians and Muslims for the position of rabbi. Then obviously a Jewish synagogue would prefer and want a Jewish rabbi to officiate in its religious ceremonies, just as a mosque would want to have a Muslim and a church would want to have a Christian, et cetera, et cetera. So we certainly understand the right to discriminate when the duties involved are explicitly religious. But there are additional areas that we'll see that religious entities can discriminate, and we'll get more into the details, obviously, as we progress. So as kind of the introduction to our topics, let's dive into our first one, the idea of introduction to religious discrimination. Religion obviously has been a big factor of human existence really since prehistory. It is an important force. It can be a force that adds meaning to life, gives people comfort and support, but it can also be a source of conflict and controversy. Obviously, our country has had interesting experiences in the area of religion. Many people who came to our country came because of persecution in their homelands, and they came here seeking religious freedom. Other people sought to be free from religion, and that might have been the reason they came to our country. So there's a lot of interesting historical aspects to our relationship with religion, but this isn't a history course, so we're going to kind of jump up to current times and talk about the laws that are applicable to our concern, to our issue about religious discrimination. And not surprisingly, the big one, the heavy hitter in our area is Title VII, and we've seen this time and time again. Of course, when I say Title VII, I mean Title VII of the Civil Rights Act of 1964. That's the big statute. Anyway, just like it prohibits race and national origin and color and gender discrimination, it also prohibits discrimination based upon religion in the employment context. So that's where we find this particular law. A little reminder, sometimes people in this class aren't sure. Well, they may think to themselves, well, I need to know what the law says, but when do I need to know the particular law? For example, I may know that an employer cannot discriminate against someone because of his or her religion, but do I need to know what the statute is? And in this case, you do. Usually if it's a Title VII or Americans with Disabilities Act or Age Discrimination Employment Act, you do need to know which particular statute that falls into. There will be certain areas that we talk about that I'll say, you know what, there's a lot of statutes here. I don't really care for you to know the particular name. Of course, if you aren't sure and I haven't been clear, feel free to send me an email and I'll let you know, is this one of these statutes that, gosh, I need to know not only what the law provides, but also which statute provides that, and when I don't need to know that level of specificity. But for this one, we definitely do need to know that Title VII is the source of our protection against religious employment discrimination. Okay, let's just a little breakdown about the worldwide adherence. The particular breakdown in our country would be a little bit different, but we obviously, as a diverse culture, have people who subscribe to all of these different religious beliefs, and the numbers change over time. So certain groups get bigger, certain groups shrink. Some of these areas you might say, well, gosh, this is a pretty diverse population. Certainly those of us from a Christian tradition look at these lists and say, gosh, there's a lot of controversy amongst these people. To lump them all together perhaps misses a lot of the granularity that we might be interested in seeing. So just because we have big sections that seem to be united doesn't necessarily mean, again, here's another area where there's a lot of controversy amongst different groups. So it's a pretty diverse world we live in. It's certainly a diverse country we live in as well. And here's a breakdown in the U.S. You can see we're about 3/4 Christian, and obviously we have some other groups here that have a smaller aspect of the population. Some of these areas are growing though, and certainly there's a portion of the population, because we can see these numbers don't add up to 100, a certain population that might describe themselves as agnostic or atheist or none of the above. There might be some other way of looking upon their religious belief system. There has generally been an increase in the number of religious discrimination claims in the last several years. Part of that may be due to 9/11 issues, and so many times the people who have been complaining have been people who are members of faith communities that are identified or associated with terrorism. For example, somebody who might be of the Muslim faith or the Islamic faith might be concerned and experience employment discrimination because some of the terrorist activities that have happened have been committed by people who identify themselves as Muslim. Sometimes other groups that may not be Muslim may also be subject to discrimination. I've heard of cases where Sikhs and other members of religious groups have been inaccurately identified as Muslim and therefore perhaps have suffered some discrimination as a result. Whatever the source of the discrimination, whatever the motivation is, of course it's unlawful, and certainly certain parts of our population have been kind of twice victimized by the worldwide terrorism situation, and then they are again victimized by the fact that others unfairly identify them with those actions. And so this can be a source of tension and controversy in the workforce. So let's talk about religious discrimination more specifically. Okay, so when we're talking about public employees, employees who work for some branch of the government, it could be federal, state, local, of course, there are constitutional protections that would apply to those individuals. Freedom of religion, freedom from religion, so to speak. The Establishment Clause that prohibits the government from establishing a religion. So those protections give government employees some additional protections. Now, since most of the time we are not going to be supporting government entities as HR professionals or as legal professionals, I'm not going to spend a lot of time on the government employee area, but I just want to flag it as an issue that can come up, and that some of the things that I say may play out a little bit differently in the governmental context. When we're talking, though, about private employers and the protections that are available to private employees, we're mainly going to be looking to Title VII for the area of religious discrimination because, as we've said before, the protections that avail to us as citizens under the Bill of Rights and in the First Amendment, that applies only to our relationship with the government. And so unless we're employed by the government, then really those don't have an application. So if I'm employed, say, at Walmart or Exxon or JCPenney, those entities don't have to protect my religious liberty or give me certain breaks with respect to constitutional protections. They do, however, have to comply with Title VII, so that's where most of the activity is going to be. We'll talk later about religious institutions, but let me kind of introduce the topic right now. Generally speaking, religious institutions don't have to comply with Title VII. There are kind of two aspects here. One is the ministerial exception or exemption, which is quite a bit larger. The other is that religion can be a BFLQ, bona fide occupational qualification, for certain staff positions. Again, you don't, let's say you run a religious school, you don't want the person who is teaching theology or the catechism, the belief system of that particular community to not be a member. Even, I could be, say, a Muslim and be very, very conversant in the fine points of Christian theology and might be able to academically teach at a Lutheran high school very effectively the particular theological ideas that exist within Lutheranism. But I'm guessing that a Lutheran high school would also want its faculty to live those ideas and to believe those ideas, not just as a mental construct, but as a matter of faith. And so understandably, that Lutheran high school would want to have people at least who are Christian and very likely who are Lutheran having those roles. And certainly our Title VII recognizes this difference. So sometimes it can be a BFOQ, a religious requirement, that the staff actually adopt and accept the theological rules and theology that is part of that entity. So we have both the ministerial exception and the BFOQs for staff members within a religious community. Let's look at a few scenarios. Actually, this is a little introductory topic, then we'll talk about a scenario. So if a place of worship has some non-sectarian activities, this is becoming more and more common. We see many churches and other religious entities that will have a daycare center or even a bookstore or an athletic club. I've even heard of some that might have a cafe or some other facility within their place of worship. And these might, in some sense, be economic undertakings. They may be charging for some of these services. They might even be a way that the particular religious community raises money for certain aspects of its larger mission. And so what about those entities? Let's say that there's a bookstore, say, or actually, let's do the coffee bar. Maybe that's even a better example because the bookstore could be selling religious books, but a coffee shop kind of just sells coffee, I would guess. And so there's not any kind of ties to a particular theological standpoint about, say, drinking coffee, for example, assuming, I guess, that you aren't a member of a religious group that opposes the consumption of coffee. So, when you're out there looking for a barista or coffee clerk or someone to sell coffee, are you looking for the best coffee brewer? Are you looking for the person who has the most friendly smile, who has the quickest hands with making the coffee and making change? Or are you looking for somebody who shares the religious beliefs of that entity? Generally speaking, the law says we're going to leave that up to the employer. We're going to leave that up to that religious entity. It can discriminate. It can say, you know what, Bob, you're a great barista at Starbucks. You're really, really good, and we fully acknowledge that you are awesome at your job. but we are going to say no to you because you don't happen to be a member of our congregation. We're going to say yes to this person who isn't as skilled, who isn't as knowledgeable, or whatever the particular thing is, simply because this person is a member or a believer in the theology that we have. So churches generally may prefer people within their own religion. And the idea here is that even though it's an expressly secular purpose, like brewing coffee, there may be, in some sense, an undercurrent of propagating their religion. For example, it might be that this is a place that there would be a spiritual encouragement environment. God bless you. I hope you enjoy this coffee. This is, a blessing from God for you, or something along those lines that is intended to bring that religious impulse to life within the organization. So that's usually okay to have a requirement that a person, even the secular part of the business, share the religious agenda of the organization. Let's consider Bob's situation. So Bob was employed by a church as a cook in its daycare center. When Bob was hired, he promised the pastor that he would regularly attend Sunday Mass held at the church. In other words, that he would be an active congregant parishioner in this particular congregation. His job is cooking, which obviously doesn't have a religious connotation to it. I mean, you can cook whether you're an atheist or a Christian or whatever your religion is. After 3 months, his employment was terminated because he hadn't attended the religious services as he had promised. Bob wants to file a claim of religious discrimination because he feels like, hey, I have the right to change my views. I'm going to another congregation, or maybe I choose not to go to church at all. Under these circumstances, unfortunately for Bob, he's out of luck because the church is exempt from prohibitions against religious discrimination, even though being a cook at the daycare center sounds pretty darn secular. The church is permitted to insist that people follow its particular religion, or, again. Let's go to our next slide, another scenario. So Mary's a librarian at a university, and this is a university that is supported by a religious institution. Again, she seems to have a fairly secular job in a fairly secular organization, but it does have some religious ties. She decides to open a bar near the university. Her supervisor tells her that she will lose her job as a librarian unless she closes the bar or sells its interest because the tenets of this religion oppose drinking. Maybe this could be Baylor, for example, where or maybe it's a BYU. So maybe a Mormon or a Baptist organization in which the members are not supposed to drink alcoholic beverages. Mary refuses to do so, so she's fired. She can bring a claim alleging religious discrimination. Now, obviously she can bring the claim, but the question is, will she win? Well, she's going to win in Texas for 2 reasons, but since we're focusing upon the religious aspects, let's look at the answer that applies to religion. The university will win because it is supported by a religious institution, and therefore it's exempt from the Title VII requirements. Now, I'll go a step farther and tell you in Texas that the university would win even if it were secular. Because it's entitled to dismiss people because of activities they engage in, even if they're completely lawful outside of the workforce. And so telling Mary that she can't have another job or something like that may not be a smart decision for the employer to make, but it's hard to see how that would be unlawful in Texas. But again, we want to focus on the religious aspects of it because in some states, employers have less ability to restrict the off-duty kind of aspects of employees' lives. So under these circumstances, Mary's going to be out of luck. She's going to have to choose between the bar and her librarian position. So when we talk about, so before we get to this slide, let's talk about kind of 2 categories of things when we're talking about religious discrimination. The first is discrimination. There are plenty of situations today, unfortunately, where people are discriminated against because of their religion. They are denied employment, perhaps because of some concern about terrorism, or just because some people don't like people of a different religion. They have preconceived notions about the type of person they're going to be. So sometimes there's just good old-fashioned discrimination that might seem similar to the type of discrimination we would see with a national origin or a race or a color claim. I don't like your kind because I don't like fill in the blanks, Jews, Muslims, Sikhs, Hindus, Presbyterians, whatever it might be, or atheists. I don't like that kind of person, and so I'm not going to hire you. That has nothing to do with the duty to reasonably accommodate. That's just good old-fashioned discrimination. And there's plenty of that out there in the area of religion. But there's also another category that we want to talk about. In fact, we're going to spend most of our time talking about the second category. And that is that many times people don't really care that much about the religion of the person they hire. That person can, be religious or not, or whatever that person wants, and as long as they're doing their job well, who cares? That's many times, especially in a secular type business, many times the philosophy that the management might have. So where we see religious discrimination coming up in this situation is when there is some obligation or some need to help that employee complete his or her job and satisfy the requirements of his or her religion. And so this is where we have this duty to reasonably accommodate. Now, a person can fail to reasonably accommodate, or an employer can fail to reasonably accommodate an employee's religious obligations and have no evil intent. For example, imagine that an employer has several devout Jewish individuals on its staff, and these Jewish individuals believe that they should not work from sundown on Friday to sundown on Sunday. And the nature of the job ordinarily requires working on either Friday night or Saturday. The employer has no problem with people of the Jewish faith, thinks they're great workers, likes these individuals, wishes nothing but good things for these individuals. But the employer is unwilling to work with the individuals to somehow come up with a staffing solution that will allow these individuals to satisfy their religious obligations and also do what they need to in the workplace. So you can see in this case, the word discrimination probably isn't really a good one because the employer isn't trying to discriminate, has no intent to discriminate, but is still putting that employee at a disadvantage by saying, well, we're sorry, but you got to pick either your religion or this job. And what the law says, well, no, in most cases, an employee shouldn't have to pick. In most cases, there ought to be a way that the employee can satisfy the requirements of his or her religion and also remain an employee in good standing. And so that's where we come up with this idea to reasonably accommodate. So again, we have the good old-fashioned discrimination where people just don't want to be around people of X religion. And then we have the situation of reasonable accommodation, the duty that the employer has to do more than just merely not discriminate. So the employer's Title VII duty to seek to avoid conflict between workplace policies and the employee's religious practices or beliefs. And again, that duty might be this big, but at some point we say it crosses the line and becomes an undue hardship. We're over in this area here. That's the undue hardship idea. If the burden to accommodate employees' religious conflict is too onerous, too great, the employer does not have to bear it. So it becomes, I guess you could say, an unreasonable accommodation. Now, the law is never going to tell an employer, well, gosh, you shouldn't have helped that employee that much. You should have stopped here. You broke the law by doing more. No, that's not going to be a claim. An employer always has the right to give more over here. It's just the employer isn't required to do that. And so this is the line. And if an employer chooses to do more, great. But if the employer chooses not to, there isn't a problem with that. We're going to talk about the definition of religion, but I like to pause here and say that usually that's not a very fertile area for an employer to advance. The courts have a pretty broad definition of the idea of religion. We'll go through several examples so you'll see kind of how broad it is. But that's fairly rare. You really have to be in some pretty quirky territory before you're likely to win by saying, that doesn't seem like a religion to me. So most of the time, the questions aren't going to turn on how religion is defined. Another area that might seem more productive, but usually isn't, is the idea of sincerity of belief. This would be a situation where, and you've probably already kind of thought to yourself, I can see how this could play out. Going back to my case of the devout Jewish people who want their Friday nights off and their Saturdays up until sunset off, you probably thought to yourself, well, gosh, there's probably a lot of people out there who aren't devout anythings, but they would like that time off. It's a good time to go out to dinner, good time to hang out with family. So a lot of non-religious people would also want that time out. And you perhaps thought to yourself, gosh, I imagine there are some people who fake their religious devotion, or at least exaggerate their religious devotion for the purposes of hopefully being able to take advantage of this duty to reasonably accommodate. And so the question comes up, well, how can the employee prove that he or she is sincere, and what kind of proof can the employer require? While it is technically true that the employee has to be sincere, it is very difficult as an employer to genuinely prove that this employee is a faker. And we'll see several, as we go through these examples, we'll see many times that some of the ways you might ordinarily think, this would be good proof, this would be good evidence that maybe it's not 100% sincere. We'll see that courts have said, nah, we're not going to go there. And so generally, I would not invest a lot of time. Now, obviously if you have a smoking gun, if you have somebody who says, listen, I'm not going to temple. I'm not doing this. I'm not going to church. I just want my Sundays off, but I'm going to say it's religion. I mean, if you have clear evidence that that is actually what's going on and the person's been clear about that, then yes, you might have an ability to talk about sincerity. But I would say 99 times out of 100, I wouldn't go very far down this path without really strong evidence. We have some more terms. Sincerely held. Of course, this is related to this bullet right here. It's a fact-specific finding determination as to an employee's fidelity to religious beliefs or practices. So this is called closely held, meaning it's not just sincere, but it's also something that's foundational for that person. It's a central fact about that person. Undue hardship, we've already kind of talked about it, but let's just refresh on the definition. Circumstance which excuses an employer from accommodating an employee's religious practices if doing so involves more than ordinary administrative costs, diminished efficiency of other workers, infringement on other employees' rights, impairment of workplace safety, or increased work responsibilities for another. Now you might be thinking, that sounds like a really low burden. I mean, if it costs really any money or ticks off really any of the workers, it's an undue hardship. So some of this discussion about reasonable accommodation sounds like it's a really, really small duty that employers have. And you know what? You're right. It is not a very onerous requirement that we see with respect to religious accommodation. Now, just because it's not a very onerous or costly duty that the employer has, that doesn't mean that the employers want to stop at that legal limit. There can be important advantages to having a more generous policy of accommodation than what the law requires. For example, an employer might find that by doing so, he or she improves the morale within the work unit. He or she may be able to retain valuable employees who happen to have some religious beliefs that require accommodation. And so just because you don't have to do something doesn't mean it might not be a really good decision for you to do something. And we'll see how the terms undue hardship and reasonable accommodation under Title VII, the religious protection, are very different than what we see under the Americans with Disabilities Act. Now, the language is exactly the same. We talk about reasonable accommodation and undue hardship. So you might think to yourself, okay, we're using the same word, so therefore, surely they mean the same thing. Well, no. Under Americans with Disabilities Act, there's quite a bit more significant obligations that employers have to reasonably accommodate. And the bar, the point at which it becomes an undue hardship, is quite a bit more onerous bar to reach than we see with religious accommodation issues. Okay, so let's go for it. So even though we're using the same terms for religion versus disability, it'd almost be better if we didn't, because it's kind of misleading. We're using the same words, but we mean them in a different way. A reasonable accommodation. An employer must make reasonable adjustments to the work environment to permit an applicant or employee to practice his or her religious beliefs. Let's pause here and talk for a second about reasonable accommodation. We've seen this word reasonable several times. We saw it with respect to the reasonable person when we were talking about sexual harassment, for example. Who decides when it crosses the line into harassment? And we talked about, the reasonable victim. We talked about the reasonable person. And here we have this term again. You may recall when we talked about reasonable before, we talked about it being an objective standard. It's no one person's quirky understanding of what might be appropriate or might not be appropriate. It's kind of an average point of view of a person in our culture. So you might, kind of take a survey of, 1,000 people, kind of what do they think on average is what we ought to do. And so it's not one person's perspective, but it's kind of a general feeling, an objective standard to apply. I say it's objective, but it does change over time. Things that our culture might have thought was reasonable to do 40 years ago might think they're not reasonable now, or they might think there's more is needed than was reasonable at different times. Because our culture changes and because the values within our culture change. I said before that the undue hardship level is really pretty low. There's not a lot employers have to do, and one term that we see for those is the word de minimis. And you can see de minimis means really of even a small amount of expense, nothing more than just a trivial amount of expense here. So if the cost of the employer to provide a religious accommodation is more than de minimis, then it becomes an undue hardship. Again, this is an example about how the reasonable accommodation duty for religious discrimination is so much more minimal than it is for disability discrimination. So if the employer can start pointing to real dollars, it's out as a result of the complying with the employee's religious practices, he or she can assert successfully that it becomes an undue hardship because of this de minimis requirement. Now you may be wondering, why do we use the same names for two different standards? I would submit to you, just historically, that the reason that we have these same languages with different standards really is a matter of history. I said before how our culture changes and we evolve and we think about these issues differently. Well, keep in mind that the expectations under Title VII were developing in the second half of the 60s, because of course the Civil Rights Act of 1964 was passed in, 64. So we had 6 years of experience under Title VII in the 60s, and then also maybe in the first half or so of the 70s, those first 10 years or so of the statute. Well, back then, courts had an idea of having a more modest expectations of what employers would do. This was still a pretty new and, I don't say shocking, but surprising expansion of the role of regulation of employers. And so courts were reluctant to interpret these broadly. And so they put the obligation, they minimized to some extent the obligation that the employers had. But of course, when the Disabilities Act came around, well, now we're figuring out what it means to comply with this act in the 1990s. The judges and courts that are making the decisions about that grew up in a post-Title VII world. They're used to the government telling employers how to manage their workforces. And so there was much more acceptance of the idea that, yeah, employers are going to have to spend money. Yeah, employers are going to have to be inconvenienced to comply with this law. So it's just a development of the law because of cultural changes, and that's why we have a de minimis standard for religious discrimination, and we don't have such a standard for Title VII, for the Americans with Disabilities Act. Then we have the ministerial exemption. Sometimes I'll call it an exception, but really exemption is the better word. It's an exemption that prevents the application to clergy members of Title VII, including provisions relating to race, sex, national origin, and religion. Now, I said before the religious ministerial exemption was quite a bit larger than the BFOQ, because the BFOQ is just about the religion aspect of it. But you can see it's lawful for a religious group to discriminate based upon race, sex, national origin, and religion. Let me give you an example. There might be a congregation that believes that women should not have leadership roles in a church. They might have two candidates, a male and a female. Both males and females are members of this organization or members of this denomination or religious group. They're both skilled and knowledgeable. They both can do the tasks well, but that particular congregation does not theologically believe women should have that kind of role. And you can see how, if we didn't have this broader ministerial exemption, that woman could contest the fact that she wasn't selected. We also see this in race and national origin bases. For example, people who are perhaps of the Jewish faith, sometimes they are in situations that they have been converted to Judaism. They were not, their family history was not tied to Judaism. They become faithful members of a congregation, and yet they still are not from a Jewish family. Their parents aren't Jewish. And so perhaps they aren't identified as eligible for certain roles within that congregation. And you could say that's a racial issue, maybe it's a national origin issue. But at the end of the day, what we really are saying here is we just want churches and synagogues and mosques and temples to be able to pick their own people really with as minimal government involvement as possible. We really want them to be free to make the choices that they want for really whatever reason that they want. And so we have exempted them from this. Now, this isn't going to apply to Mary the librarian. Going back to our story, who is the librarian at Baylor University or BYU or whatever. It's also not going to apply to Bob the cook. For those situations, they don't count as ministers because they really aren't clergy. But there's still the BFOQ, the requirement that Bob and Mary be complying with the rules of that particular religion, that would still be permitted. So we kind of see two circles. The big one, the ministerial exemption, says we're not even going to require any of the Title VII rules to apply. Then there'll be a smaller category here where we say, well, the people who work for this unit, we're not going to let them be subject to sex discrimination or race discrimination or national origin discrimination or age or disability discrimination, but we are going to allow there to be a BFOQ that these people be in good standing with their congregation. Okay, so let's talk about what is religion. I've been acting like it's a clear term, and it's not quite as clear, though, as I've indicated. So the law passed in 1964, but a few years later, the law was amended, and this was the definition that is now part of that law. The term religion includes all aspects of religious observance and practice, as well as belief, unless an employer demonstrates that it is unable to reasonably accommodate a prospective employee's religious observance or practice. So you can notice here that they've left out belief from this part of it, without undue hardship in the conduct of the employer's business. So an employer can't discriminate against someone because of belief, can't discriminate against them because of practice or observance, but they only have to accommodate the religious observance and practice. Kind of an interesting little tweak there. So Title VII covers not only what faith and belief a person may hold, but how also it's expressed through words and usually most commonly, most importantly, deeds. So how has the EOC defined the idea of religion? Well, it defines the religion to be all the moral and ethical beliefs as to what is right and wrong, which are sincerely held with the strength of religious views. So here's an example. You might find somebody who opposes abortion, feels like that this is a major theological point for him or her. But he or she isn't a member of a particular formal group of worshipers. He or she may not even have an idea of God. But this is a really defining and motivating part of his or her life that has a strong moral and ethical connections with him or her. It's possible for that person for that belief to be adequate to become a religious belief. Remember I said before that some of these things you might think, Is that really a religion? Doesn't fit your traditional definition of religion. And so you will need to have a little bit broader understanding of what the term religion means in this context. Obviously, many people who are religious oppose abortion because of the particular teachings of their church. But when even that framework is missing, that still in and of itself can be a source of religious belief. The belief should occupy the same place in life of the worker as an orthodox belief in God holds in the life of one who is clearly qualified. So again, this is opening up the idea. We're not necessarily thinking about protecting only the person who goes to a place of worship at least once a week, who prays, who can define themselves as a member of this well-established congregation. Obviously, those cases are easy. Nobody's going to be sitting back here questioning those. But it's the ones that are a little bit more atypical that we need to spend a bit more time with. For one thing, it isn't necessary that the employer be associated with any religious group. It's also not important that the employee agree with the theology of the members of the group. It might well be that he's a member of Congregation X, and Congregation X is a well-established group, and it has tenets A, B, and C. But this particular member, even though he's in a good standing, he agrees with A and B, but he vehemently disagrees with C of his particular congregation. Well, let's say C is the important issue. Well, let me make it a little bit more concrete. Let's say we had a Methodist. Well, Methodists worship on Sunday. That's their main day to worship. They don't, generally speaking, have any belief that you can't do there's no theological problem for a Methodist in working on Saturdays. And so a particular Methodist tells his boss, well, I believe that the true Sabbath is on Saturday, and that Christians like myself ought to abstain from work on Saturday. And the employer says, well, but I mean, you go to my same church, and we're both Methodists, and I've never heard of anybody thinking that. The employer goes to his pastor, his minister, who is the same minister that this employee has, and then the minister says, no, there's no theological problem with the Methodists working on Saturdays. I mean, assuming the job is an ethical job, there's not a problem. So you might be inclined to say, well, gosh, that employee obviously isn't sincere because his religious community believes something different. No, that's not necessarily true at all. The issue isn't whether the employee has the same beliefs as his or her group, but the issue is, do those beliefs have that same position of in his or her life as an orthodox belief in God would hold, even if he isn't associated with a religion at all, or even if his beliefs are fairly different. The idea of religion also can be broader than a idea of a particular God or afterlife or supernatural aspect to it. The belief may not have some of those components in it. So again, you can't just say, well, you don't believe in a God, so therefore you aren't covered by a religion. Not true. As we said before, belief in a particular God or deity is not required, so both atheism and agnosticism can be forms of religious belief and usually will be considered protected under Title VII. The religion doesn't have to be popular, doesn't have to be well known, doesn't even have to be organized or established in any particular way. The only adherent to this religion might be your single employee. The employer can't accurately say, well, I mean, that's strange. Who would believe that? That's kind of a crazy idea. And so therefore you can't possibly be sincere about believing that. In my experience, I happen to be a fairly devout Christian. If I were not a Christian and someone were to describe to me Christianity, I would probably think, my, some of that's kind of odd. And other religions, when I learn about them, I recognize that there's many people of good conscience who believe in different religions, but when you listen to it outside of that faith experience, many times people, or I would think, that's surprising, that's odd, that's unexpected. I don't see myself believing that. And of course I don't, because I'm not a member of that congregation. So the point I'm trying to make is, outsiders to religion are probably going to look upon many religions as strange, but that doesn't mean that the actual people who are members don't sincerely believe those ideas. Let's consider the scenario. So Bob seeks reasonable accommodation for religious practice that is unique to the faithful disciples' religion. And this is a group that he's shown up to talk to you. You've never even heard of this group before. It doesn't seem to fit into, Christian, Jewish, Muslim, Hindu, Sikh. It doesn't seem to fit into any of the categories. Bob's employer, again, has never heard of the religion. In order to determine whether Bob's demand for accommodation is truly based upon religion, his employer must determine whether Bob's belief is closely held, meaning sincere, and whether it occupies the place of religion in his life. He can't say, well, gosh, Bob, that's a crazy religion. What are you doing there? You can't possibly be sincere. So therefore, I'm not going to accommodate it. Or even if you're sincere, that's stupid. No, you can't say that. That's not an okay approach to religion. The issue is whether Bob's belief is closely and sincerely held and whether it occupies the place of religion in his life. Let's go through this scenario. So Bob works as a desk clerk at a hotel, which requires its employees to be on time for work, take bathroom breaks on a specified schedule, and observe certain dress codes, including that males be cleanly shaven. Well, unfortunately for Bob, he is consistently late to work and his excuses have not been very valid. He also takes breaks without following the policy. Okay, so Bob shows up to work with a beard one day and is told, wait a second, Bob, the grooming rules, you're not supposed to have a beard. Well, Bob says he has a new religious belief which requires that he grow a beard. The manager tells him he is tired of Bob not following the rules. And let's say the manager is tempted to fire Bob because this is kind of the last straw. I mean, Bob has made so many mistakes. But before Lovejoy's Sweet Hotel decides to move ahead with firing him for the beard, it should first make sure that Bob's belief is sincerely held. If it is sincerely held, then it should very likely accommodate Bob's beard. That seems like a reasonable accommodation to allow him to wear a beard. There doesn't seem to be any safety implications. And so that seems most likely to be appropriate. Now, that doesn't mean that Lovejoy Sweets can't terminate Bob eventually for being late to work or not taking his bathroom breaks on the prescribed schedule. That's probably a better idea not to fire him like the next day for being late. I mean, if Bob's gotten, 40 lates already, he comes in with a beard and says he has a new religion, and then the next day on his 41st late, you fire him. That seems like retaliation, right? And so you have to consider the totality of the circumstances, but certainly it's perfectly okay to fire people, be they religious or not religious, for being late to work or by taking breaks when they're not supposed to. You just need to make sure that the reason for your action is actually those lates or those violations of the break policy, and that you're applying those rules consistently. If it ends up that you're only firing the Muslim employees who are late to work, but the Christians and the Jews aren't, well, that's a problem. You want to apply that rule consistently, irrespective of religious affiliation. This is an interesting case. This actually arose out of the Houston area many, many years ago. And the case that developed here is that we had an atheist who wanted to be protected from having to attend kind of a prayer meeting in this particular savings and loan. Most of y'all don't know savings and loans, but once upon a time there were lots and lots of savings and loans, and there was this unfortunate financial meltdown that happened in the 1980s, which is beyond the scope of this. But anyway, Young, the woman who worked for the particular bank, would go to a once-a-month meeting, and there would be a religious component to this meeting, even though this was a secular business. And she didn't want to attend because she happens to be an atheist. She didn't mind going to the business part, but this religious part offended her particular point of view. And so she just decided that she wasn't going to attend the meetings at all anymore because she didn't want to participate in this part of the meeting. Otherwise, she was a good employer. She approached her supervisor and said, hey, would it be okay if I just not attend the meeting? Supervisor said, no, it's required. So at that moment, Young decides to quit because she's not happy there. She is asked to submit a letter of resignation, but instead she says, no, I'm being fired, and that's what happened. Now, it just so happens that it was later learned that there were employees who just would skip that part of the meeting, would step out during that part. Perhaps people who were perhaps atheists like Young, or perhaps were of a different religious affiliation. And no disciplinary action was taken against them. That was not offered to her as a choice, perhaps because her supervisor wasn't aware of that being an option. Anyway, under these circumstances, the big issue was, well, I mean, Young didn't have any religion. That's what she was opposing, the whole idea of religion, because Young is an atheist. But in fact, Title VII protects the right to believe as well as the right not to believe. And so atheists are protected by Title VII just as are people who believe. And it's not necessary that Young be involved in some kind of atheist free-thinking group. She can be an atheist all by herself, doing her own thing, and yet she's still entitled to be free from religious discrimination under those circumstances. And a reasonable accommodation would have been to allow her to excuse herself during the religious component of the meeting. This case, the venture, you do not need to know, by the way, the name of this case, but I'm providing it mainly to show you that atheists would be covered, as would agnostics. Ventures is kind of an interesting case because this was a situation where kind of a supervisory employee was trying to convert a subordinate, kind of the lifestyle subordinate. The supervisor did not approve of the lifestyle choice the subordinate was making, and was trying to persuade differing perspectives on that type of thing, on that, the belief system, and trying to lead that person to a different kind of perspective of not, for example, engaging in extramarital sexual experiences or things along those lines. Anyway, the employee, the subordinate, didn't really care for this type of proselytizing, and so she was ultimately demoted, and again, the supervisor thought that she was having sexual relations with family members and maybe with animals. She was, in the supervisor's mind, was sacrificing animals in Satan's name. And in any event, she was ultimately fired from her position. Well, the court said that the evidence of all of the assumptions that were being made about Venters, even though many of them did not end up being true, were adequate to establish that she was being discriminated against by at least her supervisor's beliefs about Venters' religious beliefs, even though they didn't end up necessarily being true. So this isn't an important case in terms of developing new law, but it's just a good example of showing how differing groups can kind of, when you have a diverse population of people who have different perspectives on religious issues, they can rub against each other. And especially when one is in a leadership position, it becomes all the more important that that person know where the boundaries are, where they are crossing the line, and to stop from crossing that line. Okay, so let's consider, what is a religion? Is it a choice, or is it an inherent characteristic? And the answer is yes, it's both. There are people who actually change from maybe the religion they had as a child. There are other religions and other religious communities that ethnicity is an important component. Some religions don't even accept people to convert, that you have to be born into that particular faith. And so it can be an inherent characteristic, almost tied in some respects like national origin is. It can be a faith-based experience. It can be a values-based experience. Lots of different ways that it can express itself, and that can be some of the issues. But again, we're going to focus on really these two questions, question 1 and question 2. Is the belief sincere and closely held? An employee's religion usually qualifies as a religion according to Title VII if the beliefs are sincere. Now, of course, this leads to another question is, how the heck are you going to be able to know somebody's beliefs are sincere? And generally speaking, you're just not. You're going to have to accept them at their word. Now, that can become frustrating because you may be sitting there thinking, I don't believe it. I don't believe this person really thinks this. They're trying to take this advantage for them, but I don't think it's right. And even if the employer is open to that, the coworkers may say, Bob gets every Friday night off? Huh. Well, I'd like to have my Friday nights off too. I'm not too thrilled with Bob getting this, particularly since I don't think he's doing it for true religious beliefs. So there can be tension along those lines as well. But as I say, generally speaking, it's quite difficult to prove that somebody is insincere about their religious beliefs. And the second point is, first one is it sincere? The second point is, does it take the place of religion in that employee's life? To prove that one's beliefs are a religion for Title VII, an employee must show that his or her beliefs occupy the same place in his or her life as an orthodox belief in God would in the life of someone else. So as we said before, atheism can be a religion. Also, strangely, white supremacy can be considered a religion, although we'll see in a few seconds that there are some limitations to this. Now you might say, well, gosh, how can we have white supremacy as a religion? Or black supremacy, or any particular group's supremacy? How could we have that? How could Title VII acknowledge that as a religion when Title VII prohibits race discrimination, for example? Seems to be an inherent contradiction there, and there is some degree of contradiction. But permitting that white employee to, in this case, the white supremacy believing employee, letting them identify and follow their religious beliefs is something that an employer might have to do. Okay, so let's consider, we're going to back away from the race, the white supremacy aspect, and talk about another iteration of this, and then we'll go back to the racial issue in a couple of minutes. This is kind of an interesting case because it's actually, in some respects, pretty typical about how these develop. So let's consider Mr. Boyer's journey. So he's hired to work for this particular employer to process beef. He's eventually promoted, and he converts to Seventh-day Adventism. And one of his beliefs, one belief of Seventh-day Adventism, which is a type of Christianity in which they acknowledge the Sabbath as the seventh day of the week, the Saturday, and that's when they worship, and that's when they believe that they should not be doing work. And so Seventh-day Adventists don't work on Saturday according to their religion. So once he makes this conversion, he tells his employer, hey, I can't work on Saturdays anymore. So the employers meet with him, and for the first 90 days, there's no problem because the plant, maybe it's closed on Saturdays, or at least Mr. Boyer isn't scheduled. But let's say there's an uptick in business, and so Saturday work is scheduled. So the employer says, okay, Mr. Boyer, you can make shift changes with your colleagues in the particular department. But Boyer's problem is that he believes it's a sin to ask someone else to work on Saturday, because after all, if it's a sin for him to work, he's basically pushing his sin off on someone else. And even though that person doesn't think of it as a sin, since in Mr. Boyer's mind it is a sin, he's actually causing or suggesting that person to commit a sin. After a time or so, the next step that happens is that the employer says, well, it will try to arrange the swaps. So instead of Mr. Boyer having to ask his coworkers, the employer will ask the coworkers, hey, who's willing to swap for Mr. Boyer's assigned Saturdays? Unfortunately, I guess a lot of people want their Saturdays off. No big surprise there. So there wasn't a lot of success in getting employees to take Mr. Boyer's schedule. Mr. Boyer refused to work on the Saturday, so he was absent without excuse, and therefore he was discharged. After he left, this IBP employer, he got another job, and the next job that he did work on Saturdays pretty regularly. And the way that he explained that was he had lost his faith. He had decided that he was not going to follow Seventh-day Adventism for a while. he, I guess, regains his faith, and he stops working the Saturdays, so he is discharged again. And so the issue is, well, did he sincerely believe that he needed to have his Saturdays off, or was he just preferring having Saturdays off? I mean, who wouldn't want your Saturdays off? Well, the court held that Boyer's previous absence of religious beliefs and his temporary loss of faith later did not support the conclusion that his beliefs were insincere. So the fact that Boyer did not initially need his Saturdays off because he wasn't yet a Seventh-day Adventist doesn't mean that he can't sincerely convert at a later time. And the fact that he had a crisis of faith at some point also doesn't mean that he can't reassert his faith later on. Probably this first one is pretty understandable. I mean, if you're not a Seventh-day Adventist yet and you become one, you can certainly understand how your previous life doesn't disprove the sincerity of your beliefs now. This is the less intuitive part of it, that a temporary loss in faith does not necessarily mean that your faith before the loss or after the loss is not sincere. You don't need to know the name of this case, but this shows how difficult it is to prove a lack of sincerity. So let's go through these examples. These are particular beliefs that you may have heard about, and some of these seem a little bit like religions, but some of them probably don't. For example, membership in the Ku Klux Klan. Is that a religion? Espousing white supremacy. I already told you this one, so you know the answer to this. Wicca, a witchcraft-related belief. Veganism, a person's legal conclusion that the belief that a Social Security card is not biblical. Belief in cold fusion. Belief in cozy kitten people, cat food. Atheism, we've already talked about that. You might be thinking some of these seem pretty unusual, and even if they're not inherently unusual, thinking of them as a religion seems strange. Well, let's see what the answers are. Okay, being a member of the Ku Klux Klan, no, that's not a religion. That the courts have said that in and of itself doesn't qualify as something that needs accommodation. But we have this case here where the employer demoted an employee after he appeared in a newspaper article describing his involvement in a religion that espouses racial separation. In this case, the court determined that the claimant's faith was a religion under Title VII, as unorthodox and even as repulsive as it was. So imagine you have a workforce, let's say it's ethnically mixed, Caucasians and African Americans, and one of the Caucasians is on the front page of the paper saying he doesn't want to mingle with African Americans. You can imagine how uncomfortable that work environment is going to be for everyone. And you can imagine how difficult it will be for people to work as a team, to have mutual respect and courtesy for each other. I mean, what a challenge to manage in that situation. But the court said, you know what? I mean, no one's asking because this is a belief. This isn't a practice. There's no need to reasonably accommodate that. But as long as Peterson, I guess that's the name of the gentleman, use that term loosely, the name of this man, as long as he's doing his job, whatever he's thinking in his head, as long as he's able to work with his colleagues in that way, he should not be directly discriminated against under those circumstances. Now, if he started saying, well, as part of my religion, I can't work with African Americans, so I'm going to have to be in my own department or something like that, that's a situation where there's no need for the employer to reasonably accommodate beliefs. It's the practices that have to be accommodated. So this kind of leads to this one. Espousing white supremacy, yes. Wiccanism, that is yes. Veganism, no. A person's legal conclusion about the Social Security card not being biblical, nope, that's not one. Belief in cold fusion, wow. Seems a little bit odd. Belief in cozy kitten people and eating cat food, nope, not a religion. Atheism, yep, that's a religion. The bottom line is that some of these are pretty strange, and what you need to do if you get an employee who's asserting one of these ideas is to say, or is to do some research. If you're wanting to take the position that this isn't a religion, it probably merits at least a little bit of research to see what courts have done with this particular set of beliefs. if it has come up as an issue. Okay, let's consider the prima facie case. So we've talked about prima facie case before, but now we're going to consider it from the perspective of reasonable accommodation. Now, obviously, if we're talking about a pure discrimination claim where reasonable accommodation wasn't in play, we would apply the traditional, the usual prima facie case. So what would we need? We would need that the employer be a member of a protected group. In this case, the employer is a member of a particular religious group. We'll make the person a Sunni Muslim. Okay, so he's a member of a religious group. He receives he's qualified for the job, whatever the job is. So he has, let's say he's already in the job that he's doing, and he's knowing how to do the job. So that's usually very easy to prove. He receives some kind of adverse employment action. Maybe he's denied a promotion, maybe he's demoted, maybe he's denied a raise, maybe he is terminated. Let's assume that happens. And then the final thing is that he is typically replaced by somebody from a different religious group. So let's say he's replaced by a Christian or a Jew or an atheist. So now he's able to establish that the prima facie case is satisfied for the discrimination claim. So it's exactly the same formula that we've seen with racial discrimination prima facie case, or color discrimination, or sex discrimination prima facie cases. But now let's consider it from the reasonable accommodation perspective. So let's look at this. Employee has a sincere religious beliefs that conflicts with a religious requirement. Okay, so that kind of has to do with that first requirement, that belonging to a protected group. The next thing that's required is the employee has to let the employer know about the conflict, that there is a conflict, and that the conflict has to do with that sincere religious belief. You know, if the employee just stops coming to work on Sundays without letting the employer know that there's a religious conflict, then the prima facie case hasn't been satisfied. If the employee says, I just can't come to work because I don't work on Sundays, that's not adequate. You have to tie it to the religion in order for the employee to satisfy his obligation to let the employer know. Because, of course, the employer isn't required to accommodate just an employee's preference. It has to be this religious requirement. And then finally, the employee has to suffer some kind of adverse job action. Discharged, disciplined, demoted, or something along those lines. So these are the three elements for the prima facie case for failure to reasonably accommodate. It's in that same category of things we saw with the other prima facie cases, but the actual equation is a little bit different for this, for failure to reasonably accommodate, than it is for kind of the traditional discrimination. But whether we have the traditional discrimination scenario or this failure to reasonably accommodate scenario, we still have that once the plaintiff has established the prima facie case, we have that burden shifting situation. So now the burden is on the employer to prove that either reasonable accommodation wasn't offered, that a reasonable accommodation was offered, or that there was no reasonable accommodation that could have been offered that was not also an undue hardship, if we're talking about a failure to accommodate case. Of course, if it's a traditional, just flat out discrimination, we didn't hire him because we don't like Jewish people, or something along those lines, well, then the employer just has to show, no, that wasn't the real reason. We didn't hire that person, not because of his religion, but because he wasn't as qualified as the person we hired, or whatever the true business reason was in the opinion of the employer. And then, of course, the employee has the opportunity to come back and say, the reason the employer gave is a mere pretext. Okay, so let's consider this scenario. Employees at Little Elm Plumbing Supplies asked the management to hold an election to determine which radio station would be played in the warehouse public address system while they were at work. The winning station was a Christian music show. After a few weeks of listening to this music, some employees just complained, saying it was religious discrimination. Maybe they weren't Christians, or maybe they were different type of Christians than what this music was. In any event, the management decided just to stop playing the music over the PA system entirely. So Bob's a devout Christian. He was really enjoying the Christian music. He's very upset that he can no longer listen to Christian music at work. And so he complains. He makes a complaint about Title VII. Unfortunately for Bob, he cannot show disparate treatment because prohibiting a certain kind of music at work Even that which had been approved by a majority of the workers is not an adverse employment action. It's just not significant enough. Bob's not out any money. He isn't having to work different hours. It's not the type of decision that would satisfy the adverse employment action requirement that we have under Title VII. Employers must make sure that employees are given reasonable, comparable options to use workplace time and resources for religious practices if they're given for secular ones, as otherwise it may appear that employers are discriminating on the basis of religion. So if your place of employment allows the knitting group to meet together over lunch to knit on their projects, or the football lovers group to meet together to watch highlights from the game the previous night, both secular activities, then that employer is probably wise to allow the Bible study group or the Torah study group or the Quran study group to meet together to talk about their religion. So generally, if you're going to give it to secular groups that aren't related to the work experience, it's probably a best practice to allow religious groups to do so as well. Let's consider this scenario. So Mary is an employee of this particular corporation, which allows its employees to use this conference room for club meetings such as the knitting club or the book club. Mary requests to use the conference room for prayer meetings on Wednesday mornings before her shift. Her request is turned down. While it's not a certain result that definitely the employer is going to be held to have engaged in religious discrimination, it, especially if it's combined with other facts, could create a situation that puts the employer at some risk. So the employer has increased risk for a claim of religious discrimination, possibly harassment, although there would need to be obviously more facts for it to be harassment. Because Mary is not given comparable opportunities to use the time and resources for religious practices as those given for other reasons. So that's something to keep in mind when you are considering the policies and practices that you want your particular employer to have. Okay, so let's consider what qualifies as a reasonable accommodation under religion. Let me just take this down for just a second. And we are going to, at this point, I'm going to end our lecture for now, and we will talk about a reasonable accommodation, undue hardship in lecture number 2. I hope that this has been helpful and interesting for you. As always, feel free to send me an email if you have questions about the material. My email is cgroover@collin.edu. Or better yet, please come by and talk to me in more detail. I'll be glad to answer any questions that you have, and we can engage in a more robust discussion of these issues. I thank you for your time, and I hope you have a wonderful day. Bye-bye.